Jersey court upholds key environmental justice law. Reported by Megan Quinn in Waste Dive. A New Jersey appeals court on Monday upheld the state's environmental justice law meant to protect residents in communities overburdened by pollution. The New Jersey chapter of the Institute of Scrap Recycling Industries, now known as the Recycled Materials Association, was among those that challenged the regulations. The groups argued that the state's Department of Environmental Protection overstepped the original intent of the law, which threatened recyclers' ability to do their jobs in the state. But the New Jersey Superior Court Appellate Division unanimously ruled that DEP did not exceed its statutory authority when interpreting the state law. It also found that economic benefits cannot be used as a reason to exempt a business from EJ-related permitting and siting rules. Overburdened communities are characterized by neighborhoods where at least 35% of households qualify as low income, 40% identify as a minority or as members of a state-recognized tribal community, or at least 40% have limited English proficiency. The REMA chapter also disagreed with how DEP defined new and expanding facilities and the criteria it used to measure environmental and health stressors, according to the lawsuit. The law defines potential stressors to include certain sources of air and water pollution, as well as the presence of transfer stations or other solid waste facilities, recycling facilities, and scrapyards. The DEP gave itself unchecked power to deny these recyclers the ability to operate or to impose limitless restrictions on their operations, which wasn't the intent of the environmental justice law and won't advance its cause, said Michael Miller, who was president of the New Jersey chapter in 2023 when the group appealed the EJ regulations. We want to work together with the DEP and our neighbors in the community on common sense regulations that allow metal recyclers to keep contributing to our economy and our environment. But the court ruled that DEP has appropriately used its authority to determine relevant census block groups and make decisions about how permit applicants must comply with EJ-related specifications. The health and safety of residents of overburdened communities must be a priority over business interests, the court found. Neither DEP nor applicants for approvals are allowed to trade fewer pollution reductions for more jobs and tax ratables, the court decision said. Long-standing environmental justice groups in the state applauded the court decision, including Ironbound Community Corporation, South Ward Environmental Alliance, and New Jersey Environmental Justice Alliance. But the New Jersey Business and Industry Association said the decision will have a chilling effect on businesses in the state. Though the state's EJ permitting rules have been in effect for more than 2 years, only 2 applications have moved through the process, said Ray Cantor, NJBIA's Deputy Chief Government Affairs, in a statement.